All right, in 25 CR 329, State of Texas versus Charles Daryl Johnson Jr., is present with his attorney, Mr. West, and the state's attorney. There's been a change in the defendant's plea. He has decided to plead guilty in the middle of this trial and has entered into a plea agreement with the state. Is that true?
Yes, Your Honor.
All right. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, Your Honor, please.
In summary, Mr. Johnson, as you intimately know, this indictment, which was handed up on March 19th of this year, alleges that on or about November 9th, 2024 in Jefferson County, Texas, you committed the second-degree felony of burglary of a habitation by intentionally and knowingly entering a habitation without the effective consent of the owner with the intent to commit assault. Do you understand what you have been charged with?
Yes, sir.
If convicted, this is a second-degree felony, which means you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range that is applicable here?
Yes, sir.
An agreement has been reached where you would be pleading guilty, and whatever sentence shall not exceed a cap of 10 years in prison. So we've got several options. Number one, you could be found guilty, sentenced to no less than 2 nor more than 10 years confinement in prison.
Yes, sir.
You could be placed on deferred or unadjudicated probation for up to 10 years. And a third option is you could be sentenced to no less than 2 nor more than 10 years confinement in prison. And then that could be suspended and you would be placed on regular probation for up to 10 years. Those are your three options. And what is going to happen is the court is going to order a pre-sentence report. We will return back after the probation office. We need to tell them
Yes, sir.
to be alerted. The probation office will go do a pre-sentence report. We will return back on January 5th, 2026. All parties will add anything else you want to include, and the court will make its decision within those parameters. Do you understand the plan? And is that your agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this indictment charging you with the second-degree felony of burglary of a habitation? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? And because you are guilty,
Yes, sir.
show you what's marked as State's Exhibit 1? Did you sign that document?
Yes, sir.
Understand it, discuss it with your attorney? All the contents all true and correct here.
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection, it's submitted. Among other things, this states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God.
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes. All right, a pre-sentence report will be ordered, and we will return back on January 5th. And please cooperate with the probation office so that they can get the information they need from you. And I revoked his bond and put him in custody, as you know.
Your Honor, I would.
What do you want? What are we going to do now?
If the court would allow to reinstate the bond and maybe even add a GPS monitor if you wanted to, so that way he could get, number one, assist me on getting everything ready for the hearing. Number two, allow him to take care of all his home issues, because this individual is not in jail like a lot of our clients. He was, out on bond. Let him take care of all this stuff in case he is sent to prison. That's not a possibility, so to prepare for that. Like I said, no contact with the victim. I think he understands now not to have any contact. That's not just physical contact. That's also any kind of electronic, anything like that. But like I said, if the court wants to give him an ankle monitor so we can monitor I think not me directly, but whoever is in charge of that can monitor to make sure he's not around where he's not supposed to be.
What's the state?
Your Honor, I think that I'd ask that he remain in jail until the time of the sentencing hearing. Obviously, he intended communications to kind of thwart our efforts to prosecute this case. So we're asking that he remain in jail until we have that the sentencing hearing.
Judge, I joined that specifically because I compare this to a situation where an individual is found guilty to an offense and is pending a punishment decision. Your Honor traditionally revokes their bond, we place them in custody. Yes, they can come back and argue for whatever at that stage, but the reality is that all of our evidence was heard already by the defendant before he made this decision. The only thing we have remaining is a 911 call, and so I would ask you to leave it as is. Let's not go searching for this man. Let's make a decision whenever it's reset.
Well, the problem is that whatever I do has to be considered fair for all concerned.
Yes, sir.
And what Mr. Johnson did was clearly, according to the testimony, violate the standard bond condition that everybody is held accountable, all defendants are held accountable for. And not only is this contemptual, where you could be placed in custody for up to 6 months for contempt, but it's also possibly something that the DA's office could bring before a grand jury for attempting to influence a witness, which is a serious offense. The problem I have is that what's good for one is good for all. And I'm reluctant for somebody to say, well, Charles Johnson, he got caught red-handed and you let him out. I want Charles Johnson's rule, please. What's fair is fair. What's fair for one is fair for all. And there is nothing more that really concerns this court more in a trial or in any pending case, but for this surreptitious behind the back door attempts to communicate with people, the victims. That's why we have this strong order. We're not talking about other witnesses. We're talking about don't communicate. It's clear you cannot communicate directly or indirectly with the complainant victim of a pending offense, nor should you go near a residence, school, job site, or other location frequented by the complainant victim. There's a good reason for that. And the court is going to hold him accountable for it. But the pre-sentence report isn't going to take long. We're going to get back here soon enough, and but he's going to be in custody, and we'll bring him back. And how much time are we talking about, generally, for this? 30 days?
It's a little second.
January 5th.
So it's like
January
5th, like 6 weeks.
Yeah. Can we do it anytime? Is there a way we can do it before that?
The only other time we have before that is December the 19th, which is our last docket. Before the holidays, I can talk to probation to see if that's something.
Try to do it then.
That's not me. I'll be here anyway.
Okay.
Be here.
But you're going to be held. You've got to purge the sin on communicating with her when you were ordered, and that's. I don't want to open this door, and I want to set an example, and I've done that before. Is when we catch somebody doing it, they always go to jail. They always go to jail. How else? It's clear. And if I didn't, then it wouldn't be considered serious. But it is, because like I say, between contempt and attempting to commit a crime by influencing a witness, those are two fires that have been fought and started. And what's good for one is good for everybody. I don't want you to be able to scamper on out of here and them say what's fair for Charles Johnson is fair for me too. And not that I don't want victims. They got enough problems. They're dealing with enough problems. I don't want them being worried about having to be harassed. And when it's found out that people aren't held accountable, I'm setting a standard. People go to jail for this. They go to jail because it's just the way it should be. This is a clear rule. It's a serious infraction. There's not a doubt about this. So you're going to stay in custody. We're going to get you back on December 19th. Everybody will be heard, and then the decision of this court will be made at that time.
Let's see, get better and stuff. So
Anything else, John, to add? What about the state? All right. That is all.
we're in recess.
All right, we'll bring the jury in and release them. Thank you. Come forward, please, sir. And we now call 25 CR 329, the state of Texas versus Charles Daryl Johnson Jr. That's you.
Yes, sir.
Present with Mr. West, your attorney, and the state's attorney. Okay, everybody?
Yeah.
Earlier, you pleaded guilty to this indictment, which alleges the second-degree felony and burglary of a habitation. A pre-sentence report has been prepared. Have the parties had an opportunity to review the report? Are there any corrections or changes to it, state?
None from the state, Your Honor.
And from the defense.
Then it is made a part of the record for all purposes. There is an agreement that's been reached where whatever sentence the court assesses shall not be more than 10 years imprisonment. So we've got no less than 2, nor more than 10 years confinement. He could be placed on deferred or unadjudicated probation for up to 10 years. And he could also be placed on regular probation. I could sentence you to no less than 2, nor more than 10 years in prison, and then suspend that and place you on regular probation. But you've been on probation before, and that was revoked back in 2002. Then it looks like in 2009, you were sentenced to 6 months in the state jail for drug conviction. So that's 2 felonies convictions. And then we have a marijuana possession, which was regular probation. That's a conviction, illegal possession of marijuana, and that was in 98. And then 03, 30 days in jail. These are misdemeanor. Possession of drugs, 30 days of marijuana. Another in 2012. There were 2 of those in different. That's odd. Look at that. That's the same exact number. That can't be right. They duplicated that. So it's true. That's got to be an error. Looks like you have 3 prior misdemeanor convictions of marijuana.
Yes, sir.
And then 2 prior state jail felony convictions. And all of these are the same thing. It's controlled substances.
Yes, sir.
All right. Go ahead.
Your Honor.
You may go forward.
Thank you.
If you wish.
Yes, please, Your Honor. We're going to ask the court to put him on probation, and we're going to let the court decide whether regular or straight is the court term of probation. Looking back at his criminal history, as you see,
His time, the credit, please. Thank you. Go ahead.
and like the court just mentioned, all of his prior criminal history is all from drug issues. The most recent one looked like the last one was in 2012 was the last conviction. So it's been quite a while since he had any problems with convictions. The biggest thing I want to point out on the PSI, Your Honor, is in the statement of interested parties that the victim of the case who I don't know if the court remembers, we actually had a trial. This was a plea during the trial. Ms. Part already testified about what was going on. But she did state there in her statement that she does not have an objection to the defendant receiving probation. So if the court was to give probation to this individual, this defendant, the victim is already on board with that, is okay with that. Also, the last sentence there, she said she asked the court to order the defendant not to have any contact with her in any way. If you were to place him on probation, you could make that an order and keep him away from her for up to, and I'm sure the court would do this, 10 years, versus if you send him to prison, we all know that he's not going to do a full 10 years, and then the court would have no control over keeping him away from his part at that point. I mean, she can go down and get a protective order or something like that, but it's out of this court's hands. But if we were to give him probation, then the court could order him to stay away from her and make it a condition, and that if he violates it, then he goes to prison for up to 10 years of his regular probation, and if the court defers it, up to 20 years. That would give the court a bigger hammer if the court wanted to do a deferred probation, where you could sentence him to a longer time if he did violate probation. Also, I think they indicated some drug treatment. I think we can get him evaluated to see if drugs are still an issue. Like I said, I know there's a history of drugs, but the last one, like I said, was not, the conviction was in 2012. So I think that probation is probably the best in a case like this. That's all I have to stop.
And then the other side. Let me ask you, before we go forward here.
Yes.
I was thinking about some things, but everybody has reviewed the pre-sentence report.
Yes, sir.
There aren't any objections here. No, okay.
Yeah. I know that's
All right. All right, go ahead, Steve.
Your Honor, the facts of this case are particularly egregious. He sneaks over to her house, snuck up there on his former girlfriend. He had taken her kids out of the house prior to that in the morning. And he just starts beating her, ends up choking her out several times where she passes out. And she's eventually able to escape. He flees, and then the kids suddenly show up again after he drops them off down the road. Again, she could have very easily died in this situation, Your Honor. I believe it warrants every bit of the 10 years. And even now, the defendant continues in his PSI to contradict the evidence that was presented in the testimony for both her and what her kids, the statements her kids had given as well. He continues to not take responsibility. And in fact, he says, I went ahead and went with it because he said I could get 20 years and I didn't want 20 years. So I still don't have him acknowledging that he did this, and he's still not taking responsibility, Your Honor. And I believe he deserves no less than the 10 years, Your Honor.
Any response?
Your Honor, we can let Mr. Johnson testify about that if you don't mind. I can call him as a witness about that.
Okay. Raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
That's right.
Lower your hand. Go ahead, Mr. West.
Mr. Johnson, part of the indication says here that you didn't break into her house, and you still believe that you did not break into the house, correct?
Right.
Okay. You did go in the house uninvited, correct?
We went into the house.
Hold on. Hold on. Hold on. It's all about what the facts are.
Yes, sir.
I asked everybody, is there any changes or corrections to the pre-sentence report? And there were none. Let me read the second line of paragraph 2 under police version. The second paragraph, on the above date, Charles Johnson snuck up on his girlfriend, Nisha Parr, as she was trying to enter her residence in Beaumont. Johnson then forced his way into the house behind her and began assaulting her. I'm sorry, he forced his way is a violent act. Okay, let's correct the record. You weren't invited in. This says you forced your way in, which means it was without her volition, and then assaulted her.
Your Honor, this is not his statement. He doesn't. What I'm getting at, I was getting to question him, is that he was there, they went in, it wasn't a situation.
He's saying the police are wrong in this report.
Well, the
Is that what he
police-
said? Well, let's come on.
Well,
Let's
let's-
get
yeah.
straight.
Let's get straight.
Is this, nobody objected to this. That's what makes me
Because that's-
unsettled. I've got to make my decision on the facts. No one objected to this. This is here. He forced his way in.
You're right.
Is this wrong or not?
That's the police version. I can't say their version is what they put down as wrong.
Do you debate their version?
We do. His
All right,
position
but
is different.
that's what, well.
It's not, we can't
but
object to what the police say.
If there's a big difference between what is being said here by the authority that wrote this and you, point it out to me. I mean, I do read this, but sometimes
Also, Your Honor,
these things pass by unless they are emphasized, because this is a big problem right now. He says one thing, the police are saying another. I'm going to be the fact finder. Go forward.
Well, Your Honor,
Go forward.
we had a trial, and the defendant or the victim even testified that. Okay, but his position is that, and I'm trying to get a question, is that he did go in uninvited, kind of forced his way through, but it wasn't a situation where he broke a window or broke a door or went in that type of way.
He was convicted of intentionally and knowingly entering a habitation without the effective consent of the owner with intent to commit assault.
Okay, but Your Honor, sometimes with non-lawyers, they don't understand the difference between breaking into and going out without consent. I think
Facts are the facts.
The facts are the
That's
facts.
all I want. It's facts.
Facts are the facts, but I think when you ask, did you break in, he's going to say no, because most non-attorneys deal with this don't consider just going in without
I've
permission
done this for
breaking.
40 years. I know what you're saying.
Okay, all right, good. That's what I'm getting at. So I think that explains his version of it, that he didn't break into. I think that's going into it. Now, whether he went in with permission or not, I don't think he went in with permission. I don't think anybody believes that.
But what we're trying to get to are the facts. What's the truth?
Right.
And somebody's version may be different from the facts. Go ahead.
Right. Well, I think the facts are, like I said, the facts are the
I'm a
facts.
fact finder.
He went in without permission and some bad things happened. I think there's no question about that. Okay. The question is in his report, I'm trying to correct his version here, or let him explain to it that it wasn't that he broke into, because I think they asked him, when asked if the defendant, if he broke into the victim's house, the defendant said no. Okay. So I think that's the issue here, is I don't believe he broke into, meaning broke in a door, broke in a window, something like that. But he did enter. If they would ask, did you enter without permission? That'd have been a different question. Okay. So I just want to make sure the court that's correct. Okay. And it's not an objection to it, because that's exactly what all was said. We're not objecting to any of that, because that's true. But I think the court needs an explanation of that's the difference there.
And it goes, upon entering the residence, this state, he began assaulting her and dragging her through the house by her hair, using his hands to strike her and threw her body about the room. Then used his hand at the front of her throat, grabbed her trachea, then squeezed her throat, cutting off her breathing and causing her to pass out. So does that look like he was invited and welcomed in there, or he snuck in behind her and immediately began to assault her? That's not forcibly entering.
When, Your Honor, there was testimony from the victim that he was in no way invited. In fact, he showed up behind her as she was going in through her garage and ran up on her.
Do you agree
and
with that?
went into the house.
Yes.
Okay.
But I'm just saying that the phrase broke into, I think that I don't want.
We're semantics now. Well, I'm talking about he committed the crime of burglary and she was assaulted.
That's why I was.
So let's move on to what the points are. We're bogged down on how he entered the building, but it was for no good purpose.
It was not with permission. It was not for a good purpose, right? But it wasn't a situation where he broke into. I think so. I don't want the court to say that he lied here, because I think his version is that he didn't break into, because he doesn't understand what the law says. Okay.
Wait, did he enter her home without her permission?
Absolutely.
Okay, so he trespassed. Okay, that's a crime.
I know. We're not saying that he
To
didn't.
get in, he committed a crime.
We didn't say that he didn't commit a crime.
Let's move forward.
Okay, all right. But like I said, I'd like to go back to the point where even the victim in this case indicated that probation would be good for him, or she would have no objection to it. And I still think that probation with a restriction to keep him away from her, and all the conditions of probation to making sure he lives right, would be good. I know he has violated probation in the past. However, in the past, it was a drug-related issue, and it's been quite a while since his last probation. So I think this is the type of case that this would keep him under the court's authority, keep him under the court's eye through the probation department. That this would be helpful for this both the victim and the defendant in this case.
So,
Your Honor, the victim here could have died multiple times. He passed out several times. And by the grace of God, she didn't end up dying and was able to escape. And who knows if she wasn't able to escape, and one of the times when she has to go to the kitchen, what would have happened in the end. So sometimes we have to protect the victims also. In these type of relationships, we know they tend to want to be lenient on the defendants. However, that's a dangerous situation, and what he did was extremely dangerous and horrible. And with those kids, again, dropping them back off over there, and they have to see the house being completely busted up, knowing their mother has been strangled and beat. I believe, again, every bit of that 10 years is warranted in this case.
what would you like to say, sir? This is your time.
That's fully told me to anything that happened.
What happened?
You going
Because he's saying something different than he is.
I went into a house without permission.
And then what?
Yeah, really. No price.
Then
No
what?
price.
Oh, she punched you first?
No, sorry. I grabbed her phone and she grabbed me and we started wrestling over the phone basically. I had no intent to try to kill her or harm her or do anything.
Well, it says you dragged her through the house, used your hand to squeeze her throat, cut off her breathing, causing her to pass out. When she would regain consciousness, you would continue your assault and squeeze her again. This assault went on for several hours before she was able to escape her house, running to a nearby business where a citizen was able to contact the police for her. She sustained injuries in the form of abrasions, scrapes, cuts, and bruises all over her body. Are you kidding me? You're going to stand by what you just told me, that really nothing, you didn't intend to do anything, this was no big deal, in spite of what this says? You don't understand and appreciate the seriousness of what happened in this person's home where she's supposed to live in peace?
Yes, sir.
Okay. Here's another statement that I don't understand that you made to the probation office. When asked how you're going to do if granted probation, you stated, "I'm going to do good. I'm not really a drug guy." Really? What are you? How many convictions do you have of drugs?
It's pretty.
Wrong. Do I know more about you than you do? Look, in 98, you were convicted. 1 year adjudicated probation of illegal possession of marijuana. In 2003, 30 days in jail. In 2012, 30 days in jail, marijuana. In 12, 30 days in jail. In 2002, let's talk about the felonies now. 2 years state jail, probated for 5 years for drugs. That's 5. That was revoked, and you received 6 months state jail. And then in 2009, 6 months in the state jail. 2 felony and 1, 2, 3, 4 misdemeanor drug convictions. But you're not a drug guy. You don't have an answer to that.
No, that's me.
Because it's just nonsensical.
I'm speaking about recently.
Well, recently, you mean since you've been in jail? You don't use marijuana in
The
jail.
last 12 years, I haven't been.
Let me ask you this. This event, was this caused by Drugs?
No, sir.
So this is the way you act when you're sober?
No, sir.
Yes, it is. Okay. Within this. Dead. If not, I'm going to find the defendant has pleaded guilty voluntarily. He is mentally competent to do so. You understand and appreciate the consequences of pleading guilty.
Yes, sir.
There's sufficient evidence supporting your guilt, your plea of guilty from State's Exhibit 1 admitted to your hearing to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt, and I am following this agreement. The agreement is whatever sentence shall not exceed a cap of 10 years imprisonment. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. You can leave.
Ma'am.
You can leave.
You step outside, ma'am.
Step outside. This is what we call justice.
Yes, sir.
Your rich criminal history. You have a rich criminal history. You're held in contempt of court. Get her. She'll be. You can't make an outburst in court.
Get it. Things else. Hey,
You're going to be given credit for all time you have served, but you can't invade somebody's home and assault them.
Yes, sir.
And with your rich criminal history, we know better.
Yes, sir.
All right. Okay, anything else to add?
No, Your Honor.
That is all. You can't make an outburst in this court.
I'm
You
sorry.
can be held in contempt of court up to 6 months now. Are you related to somebody here?
I'm sorry, sir.
Or that's okay. Are you related to somebody? Who do you know? Yes, ma'am?
Yes, sir.
How do you know him?
Brother.
He's your brother. All right. You were here and you heard what this was all about, right? Did you hear? Okay. It's a very serious thing.
Yes, ma'am.
And his criminal history was, but here's an issue when he gets out, the family needs to help with this. It's still a drug issue that he's struggling with. And he says he doesn't have a drug problem, but I think a lot of this is based upon what is out there. People don't know what's out there. What the people are manufacturing cause folks who take it to do odd things. And it's very serious. Some people are dying out there right now for some of this. But I think you're a rational thinker when you're not inebriated with drugs. And I just wish that seems to be your problem. But then you tell me I don't have a drug problem, but you've got all these convictions for drugs. But it's one of these things that the family's going to have to help you. John, I want you to talk to me about what you might be able to figure out in what plan you might be able to do to put him into a facility, which this court might consider doing before this term is completed. You know what I mean?
Yeah.
Because he needs help.
Okay.
Okay. And the family seems to be supportive of him, but you've got to be firm that his actions can't be tolerated. And it's Christmas time. It's supposed to be where the family gets together and enjoys life, and they're not with you. You're not with them, and but there's a way to avoid that. Okay. I'm talking about the field. Thank you. Let her go. Thank you so much. Yes, I am.